I hope you watched the first part. So let us do the next part, people. Almost negligible part remaining. An overview of corporate reorganization, chapter 12. In this, you have some amendments. What is that, sir? Very simple, people, not major amendments and all. One, we had already done this in the class, this case law called Mohit Agro Commodities and others. In the case of NCLAT. Sir, what had happened in this case, people? Very simple. There was a proposed merger between a holding company and its wholly owned subsidiary company. So what did they do, people? They filed an application with NCLT for the merger of holding company with wholly owned subsidiary. There was an application filed. Now, people, in the application, the holding company also demanded for not conducting any meeting of the shareholders or the meeting of the creditors. They asked a waiver with NCLT. They filed an application and they asked that can you please waive away the provision of calling a meeting? We can save some time. Anyways, this is our wholly owned subsidiary company, so we do not want to conduct any meeting. Yes, you can waive off that particular meeting. Now the question, people, it all revolves around this point only. What is that? Now, whether to order to conduct a meeting. So generally, if you remember the charts, whatever we have done under section 230 to 232, you will first file an application. NCLT will give you a order to send a notice to all your creditors, debenture holders, shareholders and other authorities, and they will tell you to conduct a meeting. Now the question is, people, now whether the entire process, is it something which is optional or mandatory on the NCLT? Meaning what, sir? Now whenever we file an application, does NCLT has an option to waive off the meeting or to not waive off the meeting? Yes, of course, we have seen one thing. What if 90% of the creditors give their acceptance in writing, then the creditors meeting can be waived off. That's that thing we have seen. Sir, what about shareholders meeting? Do we have to conduct it or do we have to waive it off? Do we have an option? In this case, people, it was decided, if we clearly read section 232, the words used are this. The tribunal may on such application order a meeting. What, people? So whether to call or to not call, people, it is completely an option given to the NCLT. What do you mean by the word may? If at all the word used here is shall, then the NCLT has to call a meeting. The words used here is, people, may. That's the reason, people, if NCLT wants, NCLT can tell you to conduct a meeting. If NCLT wants, NCLT can tell you to waive off the meeting also. So in this case, people, the whatever is a meeting that was decided, the creditor's interest was not affected. It was a wholly owned subsidiary. So there is no outsiders who is holding share. Considering all these matters, people, NCLT waived off the conducting of a meeting of the shareholders. That is what was decided in this case law. Not so important, but yes, that is what was decided. Clear? Okay, next one, sir. Okay, there is section 403. Now, what is section 403, people? I'll tell you the gist. You need not have to read this entire thing also. What is that? Now, sir, in various places, people, you will be seeing that within so many days, you have to file this form. Within so many days, you have to file this form. Within 30 days, you have to file this form. Sir, now the question is, what happens if I do not file this form within 30 days? Earlier, people, we used to consider it as a non-compliance and there was a lot of penalties and all involved. Sir, can I still file the form? Certain forms you could file, certain forms you could not file. Now, what they have done, people, in section 403, they have introduced an amendment saying that even after the time period given in the section, if the time period is elapsed, it's expired, even after that, you can still file the form, people, it is still allowed. How is that, sir? Imagine, people, within 30 days, you should have filed a form. You did not file a. People, from 31st day, you will be collected a late submission fees. An additional fees will be collected from you. How much, sir? Simple, people, for every day, it will be not less than 100 rupees. Yes, people, they will collect you at least, it shall not be less than 100 rupees per day. And people, oh sir, hey, and I'm not telling you 100 rupees only, it shall not be less than 100. the amount can be different for different class of companies. If it's a small company, the amount can be different. If it's a big company, the amount can be different. Oh, awesome, sir. And people, is this your habit or are you doing it for the first time? What, sir? Sir, you did not file the form within time. Correct. You regularly do it or you're doing it for the first time? Sir, I'm doing it for the first time. Then no problem. I can levy a penalty up to, not less than 100. If you're a big company, the penalty can, the late filing fees can also go up. Sir, no, sir. It has become my habit, sir. Every time I do it, sir. This is my fifth time, sixth time. Then in such cases, people, whatever is the amount, that is the late fee, sir, people, this can be multiplied people into 2 times, sir. Sir, which shall not be less than twice the additional fees as provided in the provision. Meaning, people, whatever is the minimum amount I need to collect from you, people, that can be multiplied into 2. If at all, people, when people, there is a default on 2 or more occasions in submitting the filing, registering, recording, or any such case. So, people, what does it generally say, people? Within time period, if you do, very well and good. If you go beyond the time period, people, I can collect an additional fees which will not be less than 100 rupees per day. If at all you do default in more than 2 or more occasions, people, in such cases, I can collect a fees which shall not be twice, which shall not be less than twice the amount involved in that particular additional fees. Clear? They have introduced this one thing, section 403. Yes, sir, just make a note of it. Okay, done. Next one, sir. Sir, there was something called as, at the last, people, we saw something called as ICSI RVO, Registered Valuers Organization. This is not there at all, people, just because the RVO part was there. In the Registered Valuers Organization part, they have added certain things, people. That's earlier thing also was not there. So whatever is added there, they have put in your syllabus. So it's not like an amendment for you, it's like an addition only. All this was not there. Now what is that? We'll see. Sir, MCA wide its notification. Rule 32C is modified by clarifying that partnership firm or company shall not be registered as registered valuer unless all the partners or directors are eligible to be under Rule 3.1 to be registered as registered valuers. Now, what is that, sir? People, when we did chapter 12, we saw something called as ICSI RVO. What is ICSI RVO? ICSI RVO is a registered valuers organization. Sir, they all come under people IBBI. What is IBBI? Insolvency Bankruptcy Board of India. You have to take up a valuation exam, people. If you clear, then you can become a registered valuer. Correct? Yes, sir. So if I'm alone, people, I can become a registered valuer. Sir, what if I want to do a partnership? Just like you guys become, company secretaries, it will start partnership, right? Sir, like that, I want to start a registered valuers partnership. Can I do it? Or I want to start a registered valuers company. Is it possible? Yes, people. Then what is the condition? The condition is if you are starting it as a partnership, all the partners has to be registered valuers. If you're starting a company, all the directors are registered valuers. That is the condition. If not, people, you cannot do it as partnership or company. You have to do it as a sole proprietor, meaning individual. Understood? So if you want to start a registered valuers partnership, that is a company or a partnership. If you want to do a partnership, then all the partners has to be eligible to become registered valuers. If it's company, all the directors should be eligible to become registered valuers. Clear? Yes, sir. Okay. So next one, further a new clause is inserted. What is that? Such partner or director shall not be a member of more than one registered valuers organization. Meaning, people, now imagine, people, I clear this exam. I'm coming under ICSI RVO. People, there are other registered valuers organization as well. Imagine, people, there is ICAI RVO. Imagine, I cannot be a member of ICSI RVO as well as ICAI RVO. This is not allowed. If you are a member of one registered valuers organization, you cannot be a member of another registered valuers organization. Clear? Okay. Next one, sir. The rule 7A has been inserted new rule which mandates that the registered valuer must inform the authority, IBBI, Insolvency Bankruptcy Board, as to any change in the personal details or modification in the composition of directors or partners. What is this, sir? So people, if any details in me changes, meaning my address, my number, any such thing changes, I have to inform IBBI. That is the individual. If at all you are a partnership, if you are a company, a new partner adds on, or one partner is leaving the firm and going. So if there is any modification, you are appointing a new director, everything people you need to inform it to IBBI, Insolvency Bankruptcy Board of India. It's clear? Huh? Next one, Rule 14A has been inserted, which specifies that the registered valuers organization must intimate the authority as to any change in composition of its governing board, appellate panel or committee after payment of requisite fee. What are these people? Sir, this also is talking about the same, no sir. If there is any change, we have to intimate. People do not get confused. This I'm talking from your point of view, partnership. This I'm talking from RVO point of view, meaning your ICSI registered valuers organization. In that there will be governing board, there will be some members. If there is any change in that governing body, they should also intimate to IBBI. So the B point talks about your regular partnership. I'm talking about business there. This is about the body, the main council. If they make any changes in their composition, they have to intimate that also to IBBI. That is what is the amendment. Not so very important. You can ignore also. It's fine. Introduction to MCA 21. Sir, what is this people? In the class only we have done people. Agile Pro was the previous thing people. Now they have added S. What does S stands for? Where did Agile Pro come? Hey, Agile Pro is not some foreigner. Agile Pro was what? Whenever you are incorporating a company, you will file 4 forms. One form is called as Agile Pro. Basically, we did this thing more in detail. I gave you a brief thing in Companies Act. We did it in detail in setting up. So Agile Pro is for that additional licenses. Your S stands for shops and establishment. So that was already discussed in the class. That is what they have given as an amendment. We have already done this. So you can ignore it. Yes, and what else, sir? Okay, with regards to Nidhi Company, there is one amendment. What is this, sir? Very simple, people. In section, okay, now see this. The Ministry of Corporate Affairs notified Companies Incorporation Amendment Rules to further amend Companies Incorporation Rules. Okay. MCA has inserted a proviso to Rule 12, wherein a company being incorporated as Nidhi will require a declaration by central government under Section 406 of Companies Act 2013 before commencement of business, and a declaration in this behalf shall be submitted at the stage of incorporation by the company. Further, INC 20A and Part B of INC 32 has also been revised to capture the aforesaid declaration. So people, there was something called as Rule 12 of Companies Incorporation Rules. In that, people, they have added something. I have given you what they have added also. This is not given by your institute. I just give it for your reference. See, first it was like this, people. An application for registration of a company shall be filed in SPICE form. We know that. Provided that in case pursuing of any of the objects of a company requires registration or approval from sectoral regulators such as RBI, SEBI, registration or approval as the case may be from such regulator shall be obtained by the proposed company before pursuing such objects, and a declaration in this behalf shall be submitted at the stage of incorporation. Now what does that mean, sir? This part they have added, people. Meaning what? If at all you are taking up any objects of a company, see, this is only with regards to Nidhi they have given you an amendment. What I am explaining you, what is the addition they have given, and then I'll explain you from Nidhi's perspective. Imagine, people, I want to start up any, mutual fund, stock market, broker, NBFC, banking business. In all these cases, people, I need to take some approvals of RBI, SEBI, or any such regulator. Earlier, what used to happen, people? First, you used to form a company. Later, we used to go and get the licenses from these departments. Now, what they have introduced, people, when you are incorporating a company itself, during the incorporation, in the SPICE forms, they have made an amendment saying that you are giving a declaration. What is a declaration, sir? As the case may be, from such regulators shall be obtained. So, provide in case of pursuing objects requires approval from sectoral regulators such as RBI, SEBI, it can be ROC, central government, IRDA, or as the case may be. registration or approval, as the case may be, from such regulator shall be obtained by the proposed company before pursuing such objects, and a declaration in this behalf shall be submitted at the stage of incorporation. What is that, sir? If you remember, people, we used to file something called as certificate of commencement of business. Once the company is incorporated, within 180 days, people, you need to get the money and you need to file INC 20A to ROC. Sir, whoever are my shareholders, they have given me the money and I've also filed the address of the company. Now everything is filed, I can start the business. They're telling you, people, before you are filing that INC 20A, that is certificate of commencement of business, you need to get an approval from that regulator under which you are coming. For example, people, if you are coming under Nidhi, you need to get a approval from central government to carry on as Nidhi. Getting the point? Yes, sir. So people, that is what is given here. What is that? If at all you are registering under any, if at all you are doing such an object which requires approval from RBI, SEBI, IRDA, or any other approval, sectoral regulators approval is required. They are telling you, when you are incorporating the company itself, you have to give a declaration that I'm going to get that approval from such authority. If they do not give me, I'm not going to start my business at all. So during the incorporation process itself, they have added that declaration that you need to give that. That is what they have given. Now read. So if you want to do Nidhi, you need to take approval of central government. Getting the point? So this is the amendment. So this is the effect. See now what they say. MCA has inserted a provision to Rule 12 wherein a company being incorporated as Nidhi will require a declaration by the central government under section 406 of Companies Act. Sir, when do you need this declaration? Before commencement of business. Okay. And a declaration in this behalf shall be submitted at the stage of incorporation by the company. So before commencement of business, you have to get the approval from central government. So you will be giving it during the incorporation only, that I am going to get that approval before I start my business. I hope this is clear. That's the amendment. That's all. Sir, what is the next one? Company incorporation, people, I've already told you, they have added that, what is that? INC 9, declaration by subscribers and directors. In the first part only told you that, see, yes or no. Whether I come under the central government approval before I'm coming. Where? Land border. Yes, the same thing. See, I'm required to obtain central government approval. I'm not required to obtain central government approval. That land border thing, INC 9, that same thing. Then okay, directors part, sir. They have added some chota mota things. What is that, sir? There is something called as, they have added a Rule 6, people. What is this Rule 6? If you remember, if you want to become an independent director, people, your name has to be registered with authority called as Indian Institute of Corporate Affairs, IICA, correct? Your name will be registered here. Now IICA, people, they will give you something called as annual report itself. Annual report. Sir, to whom will they give? They will give it to those people whoever has been registered. That is, to me, they will give people the annual report, to the independent director himself, and people wherever this person is the independent director, to that company. To both these people, IICA, the institute, will forward something called as annual report. Now what will be there in this annual report, people? In this annual report, they will clearly give your independent director. Now IICA will be conducting some seminars, some knowledge portals for this independent directors, some webinars will be conducted. Sir, how many things this independent director, did he attend? How many did he miss? How many courses has he completed? So regarding that, they will prepare an annual report regarding such independent director, and that they will forward it to that independent director as well as to the company wherever he is an independent director. This is the amendment. Simple. Annual report on the capacity building of independent directors. So what and all are the new courses they are attended? The institute shall, within 60 days from the end of every financial year, so that is technically by May 30th, send an annual report to every individual whose name is included in the data bank. So basically to the independent director, and also to every company in which such individual is appointed as an independent director in the format prescribed in the rules. What? Regarding the capacity building of the independent director. So what and all courses he has attended, all those things will be given. Is clear? That's all. Sir, regarding independent director, they have, the institute itself has answered certain FAQs, frequently asked questions, whether these people can become independent director or not. So they have given you certain scenarios, FAQs. So all these were asked by the companies to the institute. The institute has replied to that they have added to your material. What is that, people? Whether the spouse of the secretarial auditor or a statutory auditor of the company be appointed as an independent director in the company. Can they be appointed? Is it possible? What they are telling people, whether whoever is the, a secretarial auditor, imagine you are a practicing company secretary of a company, or you are a chartered accountant appointed as a company. Can your wife or husband, can they be appointed as an independent director? If you remember, people, it is not possible. In the independent director provision, we had seen the person, the relative, their partner. If at all you are working in the, CS, CA, cost accountancy firm or advocacy firms, they cannot be appointed. That is what they are telling. So hence it is not possible. Husband and wife of a CS or a CA, if you are appointed in that company, your wives or husbands cannot become independent director. Not possible. Sir, can a friend of a director be considered as an independent director? I have discussed this in the class also. Can a friend become independent director, people? Is it possible? Can a friend of a director become independent director? Is it possible? People, nowhere in the independent director provision, it always talks about only a relative. Nowhere it talks about friend. So friend can definitely be appointed, people. Why? How will you define who is friended? Huh? You can never restrict it. So because of that, people, a friend can always be appointed as an independent director. All allowed. Can a spouse of independent director be appointed as an independent director? Sir, there is already an independent director appointed. Can their wife or husband become independent director? No, people. We saw a clear thing. What? Under the disqualifications only. If at all there is any promoter or the director of the cash, their relatives cannot be. Promoter or director of the cash, their relatives cannot be appointed. So whenever I say director, independent director is also a director, right? So already you are an independent director, your spouse cannot be appointed. When you are reading this, people, what I tell you, before reading this particular provision, first to open the independent director provision, read the rules once and see. You can only answer. You need not even watch it. Yes, sir. Next one, can independent director be appointed for the first term as an additional director by the board of directors of a company? Sir, they are asking you, people, if you remember additional director, what is additional director, people? An additional director is a person who is appointed by the board of directors. 161 subsection 1 da. They're asking you, can an independent director be appointed as an additional director? Where is generally independent director appointed? General meeting, no. They're asking you, can he be appointed in the by the board of directors as an additional director? Is it possible? They're telling you, people, if you read the entire provision, it's very simple. What? So what do they say, people? Whenever you want to appoint a independent director, what do they say? First, you need to pass a board meeting, that is board resolution, plus you need to pass a shareholders resolution. Yes, sir. This is how you appoint an independent director. Okay. So now the question is, can I first appoint the independent director as an additional director? That is directors appointing. And then can shareholders approve his appointment, sir? Is it allowed? The answer is yes, people. You can appoint an independent director as an additional director, provided in the next general meeting, people, you need to make sure that his appointment is always approved by the shareholders. Shareholders' approval is always required to appoint an independent director. Remember this. Is this clear? Sir, now what is the tenure of independent director? If you remember, an independent director can be appointed for a period of 5 years. Sir, and for 2 terms. Correct? Sir, now his term, from when will it start? Will it start from the day shareholders approve or from the day directors approve? remember people, his term will start from the day that the directors has approved his resolution. Getting the point? Not from the day shareholders approve his resolution. Understood? Sir, why are we allowing this independent director to be appointed by the directors first? Because people know where it is written. It just says you need to take shareholders approval. They never say you need to take prior shareholders approval. What is the difference? If they say you need to take shareholders approval, the directors can appoint him and later the shareholders can approve him. If I say prior shareholders approval required, then first you need to take shareholders approval, then only you can appoint him as an independent director. So the section nowhere says you need to take prior shareholders approval. So because of which you can first appoint him as an additional, you can appoint him by the board meeting, but provided later it has to be approved by the shareholders meeting. Understood? So yes, he can be appointed as an additional director. This red part, if you read, everything will be clear. Is clear? Yes, sir. Can an independent director be appointed as an additional director by the board of directors of a company for a second term once his first term is over? Not possible, people. Why? We have clearly seen if an independent director has to be appointed. So the independent director can generally be appointed for 2 terms. First term once he is completed. The second term can come into picture only after passing a special resolution. Always remember that. So, can the second term, can he be appointed as an additional director, people? Not possible because special resolution is required. So, second term, you cannot come in as a additional director, not possible. Whether circular resolution is allowed for appointment of independent director, there is no restriction, people. You can pass it as a resolution by circulation allowed without conducting a physical meeting. Can appointment of independent director be done to fill the casual vacancy created by resignation of any other independent director? Now, what are they saying, people? Sir, what is a casual vacancy, people? Whenever a director vacates his office in between his tenure. Sir, whatever is the vacancies created by such directors. Sir, in such cases, can I appoint independent director also in the case of casual vacancy? Can the board of directors only fill the vacancy? The answer is yes, people, you can fill. Meaning, sir, the shareholders have appointed the independent director. Imagine, sir, this person passes away. In this case, can I appoint one more person in this position, sir? Is it allowed? Yes, people, allowed. Who can do it? Board of directors can do it. Yes, sir. Sir, but generally is it, logical to do it, sir? Should I appoint a casual vacancy? Always, people, remember, casual vacancy, what will be the tenure? Whatever the tenure of this person was, this person's tenure will also be that only. Meaning, sir, an independent director can be appointed for a term of 5 years and this can be for 2 terms. However, if you appoint him for 3 years, it will still be counted as 1 term only. That you always remember. Correct? Now, in this case, imagine whoever was a person who was already an independent director, he was already there for 2 years. Now, you appoint someone else in his position as an independent director. Now, his tenure will be for the tenure what was the original director's tenure. So, you cannot appoint a person in the casual vacancy for a period of 5 years. Not allowed. So, you will maximum appoint him for a period of 3 years. So, technically, if you are giving it as an advice, this can be done. This is allowed. I'm not telling it is not possible. But I'm telling you, the independent director cannot enjoy the complete term of 10 years. He can just enjoy 3 years plus 5 years. So it is generally a loss to him. Then what is the alternative? Best what the directors can do, instead of appointing in the position as a casual vacancy, they can appoint him as an additional director for 5 years. Additional director means, people, a director appointed by board of directors. That's all. So independent director can be appointed as an additional director. In the shareholders meeting, you can approve it. You can still get 5 years only now. So this is more logical instead of going it in this way. That is what I have given here. The board can appoint an individual either as an additional director of the act to hold office till the next annual general meeting of the company, or he can be appointed as a director in casual vacancy to fill the vacancy created in the office of independent director. So this is also possible. That is also possible. But yes, the casual vacancy always has one drawback. Correct? See? Such a director shall hold office of independent director if had not been vacated. So whatever the original tenure was, you will be only appointed for that period. Whether end of first term of director without reappointment for second term or end of second term of independent director terminate directorship of a director. Now what is this, people? They're asking you what is the maximum tenure. Tenure, people, one term of 5 years. You can again be reappointed for second term, allowed. Provided for the second term, you need to pass a special resolution. Sir, after that, can I again be reappointed? Not possible, people. There is always a cool off of 3 years. Remember that, more than sufficient. If a known person is to be appointed as an independent director, should his name be mentioned in data bank? People, generally, why is data bank maintained, people? To take the details of the director. Correct? Yes, sir. I already know whom to appoint. Should that person also be listed under data bank IICA? The law says, people, IICA is not from your point of view. It is not optional. Any independent director, if you want to be appointed, your name has to be visible and registered under IICA data bank. It is mandatory, even whether you know him or you don't know him. But yes, there are some exceptions. That is, if you're an advocate having 10 years experience, CA, CS and all, we have seen that in the class only. They've even given it as an amendment, but we have already seen that in the class. Who need not register their names under IICA? I mean, who need not clear the exam? We have seen that in the class only. Next one, sir. This we have already done, people. That is land border. If you are appointing a DIR2, DIN and DIR12, you have to give a declaration that are you coming under central government approval or not. If you are coming under central government approval, central government here is Ministry of Home Affairs. You take their approval and only then you can become a director. That's all. Okay. General meetings, people, again they have asked you some questions. What is that? Mr. X and Y, wife of Mr. X, and Mr. C, son, are the directors of XYZ Limited. They are also the members of XYZ Limited, along with 4 other persons who are brothers and sisters of Mr. X. XYZ Limited proposes to hold the general meeting at the residence of Mr. X. In this case, people, should you give a route map? In secretarial standards chapter we are done. If at all the directors only are the members of the company and they are all related, in that case, people, you need not give a route map because they already know the location. They are all related parties. Basically, they know each other. So route map is not required. XYZ Limited proposes to enter into a contract with PQR Limited. Mr. X and Mr. Y, who are promoters of XYZ Limited, holds 1.5% and 0.5% of total paid up share capital of PQR Limited, respectively. In this case, the shareholding of both Mr. X and Mr. Y should be disclosed in the explanatory statement. What is this, people? If you remember in explanatory statement section 102, we saw whenever your shareholding is not less than 2%, you need to clearly give that whatever is the explanatory statement given, there is going to be something which is with regards to your shareholding. So whenever a company is entering into any contract with the other company, if your shareholding in the other company is at least 2%, not less than 2%, you have to give a disclosure. They are telling you in this FAQ, what is that? The 2% is not only alone, people. If at all there are 2 shareholders, 2 promoters, if at all 2 promoters in this company are also the shareholders in other company, that 2% has to be taken collectively together. That is what they have given. So one person is holding 1.5, 0.5. They both are promoters in this company. They are also shareholders in the other company. So you have to take it as collectively. You still have to give a disclosure. You have to give it in the explanatory statement. Say a company XYZ Limited wish to hold its general meeting at a shorter notice. This we have done it in the class also, people. What is it? People, shorter notice, people, can I conduct it? Yes, sir. How, sir? You need to get a consent from 95% of the members entitled to vote at the meeting. Correct? Yes, sir. Sir, now what is that shorter notice, people? Generally, I give 21 clear days notice. But if 95% of the members, if they agree, people, then I can conduct the meeting even in a shorter notice. Sir, what do you mean by shorter notice? If 95% of the people agree in writing, I will ask them in the morning. They will reply me in the noon. Can I conduct the meeting in the evening? Is it possible? Is it possible? So can I complete this entire transaction in one day only? I'll ask them in the morning. People, is it okay if I conduct the meeting in the evening? In the noon, people, 95% of the people will reply. Sir, in the evening, I'll say, okay, let us conduct the meeting. Is it possible? The law says, people, never forget proxy provision. What is proxy provision? We have given 48 hours to deposit the proxy forms, right? Proxy form has to be deposited 48 hours before the meeting. So in this case, imagine 95% of the people replied. 5% of the people are not yet replied. What if they want to send the proxies to the meeting? So because of which, people, you cannot conduct the meeting on the same day. Even though I say shorter notice, you cannot conduct the meeting on the same day because you have to follow the proxy provision. That is, you need to give at least 2 days prior notice because proxy provision has to be fulfilled. Sir, we have we have one more doubt. What? Sir, what if instead of 95%, entire 100% of the people agreed? It's okay, we will come and attend the meeting even if it is held in the evening. Now, can I conduct the meeting on the same day? Now, obviously, you can conduct, people. Why? Because the entire 100% have replied. Now, where is the scope for proxy? Now, they have everyone agreed that we are going to come for the meeting. Now, 5% doubt itself is not there. Now, you can conduct the meeting on the same day. When 100% of the people have replied. If it is 95%, then you cannot conduct. That is what is given in this provision. Clear? This and this. That is what we discussed. Sir, consider the above illustration. Now, what are those people that we have seen? No, okay. Okay, imagine, people, in my company there were 500 shareholders. In my articles of association, I have said that my quorum shall be 100. Okay, sir. Now, people, obviously, whatever is given in articles, that has to be present for a quorum. Now, what happened, people? One day, 450 people decided to leave the company. The rest of the 50 people acquired the shares of this 450 people. So today, how many shareholders are there in the company? Only 50 are there. But according to my articles of association, people, my quorum says 100. But the number of shareholders in my company only are 50. Now, how can I even conduct a meeting? I know many of you are telling, sir, what is there, sir? We can alter the articles of association, no, sir. To alter the articles of association, you have to call for a general meeting. You have to pass special resolution. But to pass special resolution, first the meeting has to be valid. For the meeting to be valid, first the quorum should be present. But the quorum only is not present. No. In this case, they said, people, whenever such case happens, the entire 50, if they are present, it will still be considered as a quorum. Even though if it is less than 100, the entire 50, if it is present, it will be considered as quorum present. Now you can alter your articles of association, reduce your quorum, it is valid. Sir, what if the entire 50 is not present? Then it will be considered that quorum is still not present. That is what is given in this FAQ. See, these are all the questions asked by the various people to the institute. Institute will reply. Like, yes. Next one. Assume that general meeting of a company, people, wherever there are multiple proxies given, then what will happen, people? Whichever proxy is given, what happens? Which will be valid, people? Is it the proxy given first or the proxy given last? Always, people, the proxy which is deposited last will be valid. However, you should have deposited at least 48 hours prior. That remember. Virtual meetings, I have told you in the class only, people, there was something called as Rule 4. Certain things you cannot conduct it by a virtual meeting, electronic meeting, video conference. Certain matters we could not discuss. What are that matters? Approval of financial statements, approval of board report, approval of prospectus, approval of financial statements by audit committee. These things were given under Rule 4. Now what has happened, people? That Rule 4 has been omitted. Now indirectly what has happened, even these things can still be conducted in video conference meeting. It is allowed. Yes, this we have done it in virtual meetings also. I have done it in secretarial standard also. Just remember that. Next one, sir. Sir, Achintak Kumar Barua, we have done this case law in the class only. What is it, people? In this case law, there was a question. What? A director said one company has to give him an option to attend a meeting through video conferencing. But a company is of the opinion no, to give an option to directors to attend physically or through video conferencing. It is an option on the company whether to give it or not. A director can never demand for it. In this case, it was held that people, it was not optional on the part of the company to give an option to attend the meeting through video conferencing. It is not an option. It is mandatory for an company to give an option for the director to attend the meeting electronically. It is mandatory. You have to give him an option. It is not optional on the part of the company. You have to give him an option. That is what was decided in this case. Clear? That is your virtual meeting. That are the amendments, people. And last, there is something called as miscellaneous. What is this, people? We have already done this, not here, people, in setting up of business entities. The name change. So this provision is not very much relevant here. It is relevant in setting up of business entities. Whenever a company does not change its name, the central government can only allot a name. What is that? The order of regional director not complied. The company, the government only will allot a name. The company will have to follow that name. Later, if they want, they can change. That was this amendment. Yes, sir. Yes, people, that's all. And there are some amendments in Nidhi and all, people. Nidhi is not relevant here, or LLP is not relevant here. Let us do all of that in setting up. Is this clear, all of you? So this is it, people, in company law. A simple provision, nothing much and all, no much amendments. Just remember these things and go, more than sufficient. Yes, people. So I hope you guys are all well on track. I hope you guys have studied, prepared well. So I wish you guys very, all the very best for your exams. Do well. May God bless you. Good luck, people. Thank you so much. See you. Bye-bye.